Mr. Manalis.
Good morning, Chief Justice Marshall and Justices. My name is Richard Manalis. I represent Russell Reill. This is an appeal from a matter in the Norfolk Probate Court. The parties, formerly husband and wife, were divorced in July of 1990. Subsequent to the divorce, Mr. Reill moved to Utah, and Mrs. Klingel, I believe that she took her maiden name, moved to New York with the two minor children. In January of 2002, the youngest child of the parties turned 18, and Mr. Reill terminated the child support. In April of 2002, Ms. Klingel brought an action for contempt in the Norfolk Probate Court. A motion to dismiss based on lack of jurisdiction was filed on Mr. Reill's behalf, and this motion was allowed. Contempt was dismissed. In 2003, Mrs. Klingel moved back to Massachusetts and filed a new complaint for contempt. On Mr. Reill's behalf, another motion to dismiss for lack of jurisdiction was filed in the Norfolk Probate Court. This motion was denied. Mr. Reill was found in contempt and a judgment entered, and this is an appeal from that judgment on the issue of jurisdiction. The pertinent statute from the position of the appellant is found in in Chapter 209D, Section 2-205, and it specifically reads as follows. A tribunal of the Commonwealth issuing a support order consistent with the law of the Commonwealth has continuing exclusive jurisdiction over a child support order, then subsection 1, as long as the Commonwealth remains the residence of the obligor, the individual obligee, of the child for whose benefit the support order is issued.
But counsel, does that mean, let's assume you're correct that the court loses exclusive jurisdiction over that order once the individuals leave. But does that mean the court loses all jurisdiction over their enforcement of their orders?
Yes, that would be our position, and probably for two reasons. First, there's a protection to the obligor. For example, if the obligor remained in Massachusetts and, for example, the spouse in this case moved to California and an unemancipated child was in Michigan, that would allow the obligee to do some forum shopping. And I believe the word exclusive applies to protect the obligor in that situation, that the forum would remain in Massachusetts. Once the parties have all left Massachusetts, again, this would prevent forum shopping on the part of the obligee, and that the term exclusive is for that purpose.
You're saying then that the court couldn't even have power to enforce its own orders?
I'm saying that the court would not have the power to enforce its own orders because the word remains is in the statute.
Well, but if I look at the commentary, even to the 1996 version of the Uniform Act that this is based on, the comments indicate that the reason the jurisdiction is lost if the parties have permanently left the issuing state, permanently, suggesting obviously if somebody comes back, nobody has left permanently. And it's because the state would then have no appropriate nexus with the parties or the child. If all of them have left the state, there's no appropriate nexus, notwithstanding the fact that this is the court that issued the order. The minute one of them returns, any one of them returns, then no one has permanently left, and there is, again, an appropriate nexus. Because don't the comments suggest that remains refers to a situation of, whenever, that you can leave and you can come back, and recreate the nexus, and then you're fine.
No, our position, Your Honor, is that this may have been the intent, as the commentary so indicates. And in 2001, it's significant that the uniform statute was changed to eliminate the word remains.
With respect to the modification.
And even there, they said this is not intended as a substantive change, but simply a clarification of the original intent. That's what the comments say. They say this is not substantive change.
We feel that the word remains has to be given its common and usual definition and application as imparting a degree of continuity, and that notwithstanding the commentary, that the intent of the original draftsman may have been, as you stated, to provide a recognition of nexus when someone returns.
This is not a criminal statute, so what we're trying to look at is what the legislature intended. The legislature most assuredly did not intend, if nothing else, that the obligee would have to hop from state to state to state to state to pursue an obligor. That is absolutely clear.
If the obligor had remained, or one of them had remained in Massachusetts, that definitely would be the situation, that there would not be forum shopping, there would be exclusive
No.
continuing
She's not-
jurisdiction.
She's now in New York,
That's correct.
correct?
At this time, yes.
And then she comes back.
She came back, she's left, but at the time of this case, yes, she was in New York, and then moved back to
And
Massachusetts.
as Justice
And filed, yeah.
Sossman said, then a Massachusetts court is saying, well, I don't even have I don't have anybody here, right? And then she can go into New York court, and under the full faith and credit, there will be an enforcement.
We acknowledge that the commentary indicates an intent that if there is a nexus to Massachusetts, one person residing here, whether there's an interval of non-residence or not, that Massachusetts could rationalize jurisdiction. Our position is that the word remains is in there. When it was removed in 2001, the Massachusetts legislature chose not to enact that change.
Could I ask you, under your interpretation, say all three of them left, New York, Utah, whatnot, suppose then all three of them came back to Massachusetts?
Then this would be the only state having a forum, but not under that particular statute,
Well, under
only
what
because it was
statute
now
would
the
it be?
residence of the obligor.
Under what statute would Massachusetts have jurisdiction if the party, if nobody had, quote, remained, under your interpretation of remained, they've gone, and then they've come back? What statutory section am I
Under
looking
our
at?
interpretation, once all parties have left Massachusetts and Massachusetts has lost jurisdiction, the state of jurisdiction would then be the state of residence of the obligor. And if he then returns to Massachusetts...
And what is your basis for saying that? I mean, tell me what statute would confer jurisdiction on the probate court to enforce the original order if all the parties had left the state and then all the parties came back? What section in 209D or elsewhere would I be looking at?
I can't give you a specific reference, but I'm saying that if the obligor, wherever the obligor is when Massachusetts loses jurisdiction, that's the state of jurisdiction. If the obligor comes back, he would not have jurisdiction under this statute, but under the provision, and I can't cite it for you, that simply says where the obligor resides, that's where the obligee can come to enforce the order.
Could I ask you this? If you take a look at 2205C,
Yes.
that clearly is addressed to when a tribunal of the Commonwealth loses its, and I quote, continuing exclusive jurisdiction, correct?
That's correct.
Doesn't that suggest that under A, you have continuing exclusive jurisdiction except for very good reasons when a court in another jurisdiction modifies? In other words, what the legislature is saying is, I've got a court order, for example, that says that the wife has to pay $500 a week. A court in New Mexico then says the wife has to pay $200 a week. The husband comes into Massachusetts, or is in Massachusetts, and wants to enforce the $500 a week order. This statute says, no, this court has lost its continuing exclusive jurisdiction. Correct?
I fully agree. And that is the first several words of that particular provision, subsection C, state that if a child support order of the Commonwealth is modified, that's a unique and specific situation. It deals with tribunals having the jurisdiction to enter a modification and what happens subsequent to that. There was no modification in this case.
But the remainder of that section says, same hypothetical, even though the husband comes into Massachusetts to seek some change, if in fact the prior order issued by Massachusetts hadn't been complied with, that section permits the court to have jurisdiction over any amounts that accrued before the modification. So the court's original order until it was modified is enforceable in Massachusetts.
I don't feel that that's inconsistent with A, because if there has been a modification and all other factors are in compliance and in line, then yes, the Commonwealth could enforce that part of its order that had not been modified by a foreign tribunal. I don't think that's inconsistent with, I think it's additive to subsection A, which requires, or A1, which requires the continuity of residency.
A foreign tribunal doesn't get to modify it unless Massachusetts has in some sense already lost continuing exclusive jurisdiction, i.e., under circumstances where everybody has left Massachusetts. So when you get to C and D, by definition almost, you're talking about a situation where people have left, and yet Massachusetts can still enforce the original order, aren't you?
The situation on the modification has I believe, a different criteria, that another state may have provision in its laws that state that any children or dependent children that are residents in that state gives that state jurisdiction to modify an existing foreign
Then what happens
judgment.
to the word exclusive?
The word
Continuing exclusive jurisdiction to prevent foreign shopping of exactly the kind you're now describing.
Well, in the case of a modification, if the dependent children and the custodial parent are residents in a foreign jurisdiction, the laws of that jurisdiction may be contrary to, the laws of Massachusetts relative to allowing that foreign jurisdiction to hear the case on a modification. What we're concerned with, I think, is strictly subsection A that deals with the enforcement, and separately and distinct from another criteria which may grant or deny jurisdiction in a modification case.
Well, we are concerned with enforcement, and that's why I look to Section C and see that even if the Massachusetts court has lost continuing exclusive jurisdiction going forward, it still has jurisdiction to enforce its prior orders. Isn't that what C says?
C says that if there has been a modification, regardless of the basis on which that modification may have been issued as far as jurisdiction is concerned, Massachusetts still would have exclusive jurisdiction to enforce.
Its prior orders.
Its
and
prior
failure
orders.
to have complied with its prior orders, which I take it is what this is all about? This is
Yes.
contempt for failing to comply with the prior order.
Very definitely, but C would still have to be read in conjunction with A1 that has, at the time of this matter, the requirement for continuity of residency. The two are not inconsistent when viewed together. Massachusetts, yes, can enforce an order, even if it has been modified by a foreign jurisdiction, but can only enforce that order if there has been a continuity of residency. And I think the two must be read together, and that C just provides a situation for enforcement in the event of a modification. It doesn't cause
Well, it's a modification that results because Massachusetts has lost its exclusive jurisdiction somehow.
Well,
So that's how the thing gets modified in another state, and then a party here seeks to enforce the prior order, can do it.
I wouldn't say it was modified because Massachusetts lost jurisdiction. I would say it was modified possibly because
Exclusive.
of foreign jurisdiction, yes.
Yeah, because if
Gained jurisdiction.
See, if a child's order of the Commonwealth is modified by a tribunal of another state pursuant to a law substantially similar to this chapter, I'm suggesting one substantially similar in its jurisdictional requirements, then a tribunal of the Commonwealth loses its continuing exclusive jurisdiction with regard to prospective enforcement and may only enforce. And I do think, C to me does seem to envision that modification consistent with C in some other jurisdiction is only going to occur if Massachusetts has lost its exclusive continuing jurisdiction for some reason.
If the parties have vacated.
And yet,
Yes.
despite that, Massachusetts is going to retain the ability to enforce the original order as unmodified.
Are you saying that Massachusetts' authority to enforce its order is only the authority to enforce the order up to the point that it has been, up to the point in time that it has been modified, to the extent that the order had not been satisfied?
No, I'm saying that Massachusetts retains jurisdiction based on a residency requirement,
So you're-
continuous residency.
You're saying that Massachusetts can enforce an original order, notwithstanding prospectively, notwithstanding the fact that it's been modified by a different court.
As long as there's been continuous residency. That's why I say it's not inconsistent.
Well, it isn't. There are two inconsistent orders that are floating out there.
Well, your position simply cannot be correct. If there's been a valid modification by another tribunal, as Justice Sussman suggested, then let's say reduces the wife's child support payments or whatever they are to $300. The husband can't come into Massachusetts after that, the entry of that valid modification, and seek $500.
I'm saying, husband, if Massachusetts has lost jurisdiction and the order is modified, then he could not come in. I
No,
think both portions of statutes would have to be satisfied for the jurisdiction to exist.
Thank you, Mr. Angeles. Mr. Baldacini?
Good morning, Your Honor. May it please the Court, Frank Baldacini representing the appellee, Carrie Klingel. I think that what has to be clarified with respect to the Uniform Interstate Family Support Act, which is 209D, is that there is a difference in how it's treated with respect to enforcement and modification. And what creates confusion to some degree is the words continuing exclusive jurisdiction, which is mentioned in A. And I think the appellant has indicated that that somehow has something to do with the power of Massachusetts to enforce its orders as opposed to the power to modify. I think the statutory framework is fairly clear. If you look at the comment in the original act, it says the issuing tribunal has continuing exclusive jurisdiction over its order, which in practical terms mean that it may modify its order, which would indicate that when it is referring to continuing exclusive jurisdiction over a child support order in subsection A of 209D, it is referring to the power of the court to modify that order, not to enforce its order. And I think that's clear from reading the comments. And I think where the appellant missteps is that he's looking at that as continuing exclusive jurisdiction as the power to enforce the order. The comments further go on to say that it should be noted that nothing in this section is intended to deprive a tribunal which has lost continuing exclusive jurisdiction of the power to enforce arrearages that have accrued during the existence of a valid order.
Mr. Baldacini, let me, Chief Justice Marshall, let me see if I can understand you, and you may well be correct, but I just want to make sure that I'm understanding your argument.
Certainly.
Massachusetts issues a support order that says the wife must pay $500 to the husband in child support. The wife moves to Texas, and the husband and stops making the payments. I take it that you are saying that the husband could, if he wanted to, go to Texas, commence an action to enforce a valid order. He may seek to attach property of the wife in Texas. He may do all kinds of things with access to a Texas court. That's one possibility. Or you're saying the husband could go into a Massachusetts court, get a judgment in the amount of whatever the arrearages are, and then go to Texas to enforce the judgment.
That's exactly what I'm saying, Your Honor. I'm saying that the husband in that particular set of circumstances would have the option, and Texas would have to give full faith and credit to the judgment of Massachusetts.
But what could not happen is if the husband, no, if the wife moved to Texas, the wife and the husband remained in Massachusetts, the wife could not go into a Texas court and say, modify the order. I don't want to pay $500. I've lost my job. I should only have to pay $5.
That's correct. I think under those circumstances where one of the parties still is in Massachusetts, that Massachusetts would still maintain the authority and the exclusive jurisdiction to modify. I think what the statute...
And I take it as well, if I may just continue, I take it that if during that period of time the husband was a worked for a consulting company, actually moved to New York or Rhode Island. I mean, moved for a year, then moved back to Massachusetts. You're saying that the husband could then again go into a Massachusetts court and get a judgment.
I think that's the circumstances we have here. I think where it becomes, where the statute is trying to address, Your Honor, is a situation where in that case the husband moves out of Massachusetts to someplace like New York, where now he's in New York and the wife is in Texas. And in a situation where there's a modification or one party seeks to modify the order, if the husband wanted to modify the order, he has to play a so-called away game under the statute. He cannot file in New York. He has to go to Texas to modify the order at that particular point in time. But I don't think the intent of the statute was to send, in this particular case, was to send a woman who was divorced in Massachusetts to move temporarily out of state to New York for a period of time, move back to Massachusetts, where there has been no modification, no other state has taken jurisdiction of this case, and where she seeks to enforce this order in Massachusetts, that she's told, no, you can't enforce the order in Massachusetts, you've got to go to Nevada to enforce this order. I think under the statute, it's clear that even where somebody is a recipient of child support, in the example cited by my brother, where the recipient of the child support moves out of Massachusetts and the payer, the obligor, remains in Massachusetts, that the party, the obligee in that case, is able to register or go through a procedure to register the child support in another state to collect the money from Massachusetts. So there's a procedure for doing that. So if the recipient of the child support can do that, why can't she collect the child support in the state that issued the order? And I think where this goes, where the argument goes askew, is that to say that Massachusetts somehow loses jurisdiction to enforce its own order because a party temporarily moves out of state for a period of time is misplaced. I think the probate court has the authority to enter that order. They had jurisdiction. There's no question that the defendant in this case, in this contempt, was served. There's no issue as to whether the money was paid, money is due and owing. It's solely a question as to whether Massachusetts has the authority to enforce that order. And
what's the amount of unpaid child support?
I think the amount of unpaid child support in the order was somewhere around $35,000 with the obligation which was in the judgment, which is in the appendix that was attached. And that order is being paid. So I think that where the difficulty comes in is the use of the words continuing exclusive jurisdiction that somehow is being used to say that power to modify is comparable to power to enforce. And it really is not the same thing under the statute. I think the framework of the statute is, as I just described, was to deal with situations where, from state to state, and modifications, and to try to set up a framework under which there could be some rational way of dealing with modifications of child support orders when parties move from state to state and when the original state loses jurisdiction. And I agree with the operations that under subsection C, that it's clear that when the parties both move out of state and when another tribunal in another state modifies an order, Massachusetts still retains jurisdiction to enforce its order up to the date of the modification from the other state, and I think that's what subsection...
I see that in the statute, but then how is that consistent with your earlier statement that if, in fact, both parties have moved out of state, the order is still a Massachusetts order?
Correct.
It cannot be enforced in Massachusetts.
Well,
in this case, the mother living in New York came to Massachusetts to file the action and was told, and that was dismissed.
Well, that was dismissed. I'm not necessarily sure that I agree with that dismissal, Your Honor,
that's what I'm getting.
Because I think Massachusetts did retain jurisdiction to enforce its order.
But you said at some point the statutory scheme requires that the person play an away game. Where is that in the statute?
Well, that's when I'm dealing, I think that's part of the confusion. That's dealing with a complaint for modification, Your Honor, which means is that if both parties leave the state, I think what the intent of the statute at that point and what the statute clearly provides for is that if one party lives in New York and one party lives in Texas and they both have left Massachusetts, and let's say the wife is receiving support and she lives in New York, if she wants to modify that order to get an increase, what the statute says is rather than have the person in Texas have to go back to New York, the statute requires in the interest of equity that the person seeking the modification has to go to the state of the obligor in that particular case.
But that would not, that same principle would not apply to enforcement.
That's correct, and that's the difference. I think what the statute provides is that the statute's providing a scheme for modification as opposed to enforcement, and I think the comments to the section make it clear that a state doesn't lose its jurisdiction or its power to enforce its own orders, and it will only lose that enforcement power up to the time that another state takes jurisdiction of the case and modifies the order. Once the other state modifies the order, then Massachusetts has no power to go beyond that date of modification. And I think that's how the statutory scheme work was set up to work. So Massachusetts doesn't lose jurisdiction to enforce its order in that particular case.
I'm curious about your comment that you don't necessarily agree with the judge's original action in dismissing the complaint for contempt when the wife filed it when she was living in New York. But under the way you described the workings of the statute, when the wife filed the original complaint for contempt, she was living in New York, and both parties were living out of state, and the judge would have no way of knowing that she was planning to move back to Massachusetts, if in fact she even were. So under your hypotheticals, it was proper to dismiss that original complaint.
No, I think I'm referring to the power of modification. So, for instance, in that particular case, the wife was only seeking to enforce the existing Massachusetts order. She was not seeking to modify the order. And I think that's the difference. The hypothetical I was discussing was, when I was playing the away game, was modifying the order. I think enforceability of the Massachusetts order remains with the Massachusetts court to the extent that the order has not been modified by another tribunal. So in that particular case, although the party had gone to New York and one party was living out west at that particular time, there had been no subsequent modification by another tribunal. All the Massachusetts court was asked to do at that particular point in time was enforce the order that had been entered in Massachusetts.
Mr. Baldessini,
can I just follow up on that?
Yeah, sure.
So your position is that if both parties are living out of state, Massachusetts still can enforce the order as long as it's not modified?
Correct.
Okay.
Mr.
And I think
Baldessini.
that's what the statute says.
Okay. Mr. Baldessini, that's a very interesting point. This is an extremely experienced judge who entered that order, and he says so quite specifically. I'm talking about the 2002, when
Correct.
both parties were out, that he no longer has jurisdiction. I know that issue is not in front of this court, but it's helpful as we interpret the statute. Are there cases from other jurisdictions which have had this, the similar statute where it's a little odd because then you get into the interstate, but where an order such as the one that was entered here dismissing a complaint for this is a complaint for contempt, correct? I think that's what she was seeking.
Yes.
Yes.
Where a judge has said, I can't issue it because neither party is a resident of the state.
Well, I don't think it's anything that's stated in the statute. I think Judge...
No, I'm just asking you whether other jurisdictions have reached a similar...
I haven't seen another case. The cases that were cited are not on that specific point. There have been some cases decided as far as up to the point as to what arrearages they can enforce. I don't think any of the cases cited in the briefs deal with specifically with a case where two parties have left the state and go back to the so-called home state to enforce the judgment in that particular case. And it's probably not a common occurrence because the way I think the statutory scheme works,
it would
usually be someone filing in that case in New York to get the money paid through to New York and
Correct.
file through some type of recognition of the judgment at that point in time. So I don't know if that situation comes up. The reason, and I agree with your assessment of Judge Copeland, he's a very experienced jurist, is that, and I don't know what his reasoning was in that particular case, but judging from what the comments in the section were under the Act, is that it basically indicates the tribunal never loses its jurisdiction to enforce its own order.
But there is something odd about it, though, where nobody is in Massachusetts anymore, particularly the obligor, but not even the person who benefited by the order is still here, and there's no property in Massachusetts. There's just something about it that doesn't sit right.
Well, I don't disagree with that, and I think that the reason it doesn't happen very often is because...
There's constitutional concerns.
Well, there's most obligors, I think, obligees, rather, who are receiving child support would file to get the money either through the local, as in the Department of Revenue here. If you're in Massachusetts and you want to collect, you can go through the Department of Revenue.
Yeah, you go through the standard interstate.
And that's correct. And so that's what would happen mostly, so I think it doesn't happen that often.
Yeah, it was sort of odd that she took on the additional hurdle, if you will, of coming back to
That's correct.
filing in Massachusetts rather than in New York.
It's not a hurdle that most plaintiffs would want to tackle in those circumstances, and so it was somewhat of an odd, and I don't know what the arguments were or what the position was at the time. I wasn't involved in the case as to what arguments were presented to the court at that particular time.
Where was she living in New York?
I think she was living near New York City at the time, Your Honor.
So she came back to Berkshire County, was it, to enforce it?
No, Norfolk County.
Norfolk County?
Norfolk County. And I can't tell you I can't shed any light on
You
what the...
didn't represent her, I
I
take
did
it.
not represent her at that time, and I can't shed, and I wasn't involved in those proceedings, so I can't shed any light.
Was it a pro se filing?
At that time, trying to remember the file, I believe it may have been a pro se filing at that time. And not to go too far off the record, but I believe there had been some difficulty in collecting money through New York from some administrative purpose, and there may have been a desire to think that maybe it would be easier if someone went through Massachusetts. And I think there was something along those reasonings, but I don't think that's a common occurrence. But from the statutory framework, I think Massachusetts has that power to enforce its order, and I don't think there's anything statutorily in the Interstate Family Support Act that would deprive Massachusetts of that jurisdiction. And I don't disagree with Justice Spina's argument that there's something strange about how two people from out of state, but you're looking at collecting an order that was entered with jurisdiction in Massachusetts, and you're looking at a enforceability issue as opposed to a modification issue.
Well, I'm actually looking at the docket, and it appears to be, the entire thing appears to have been triggered by a motion for clarification, which is why it just, it's not entirely clear.
Well, what I would add, Your Honor, obviously this is a somewhat confusing area for a lot of people to comprehend, and it may have been that the decision was made in whatever reasons, I'm not sure.
Well, because his judgment is actually entitled an order on defendant's motion for clarification. In any event, it's an interesting question.
So, unless there are any further questions, for that reason, the judgment should be affirmed. Thank you very much.
Thank you, Mr. Baldassini.